Can the court order a road victim's compensation to be paid to the public trustee or ARB? There is a new trend in Malaysian vehicular accident cases in court. Recently, lawyers acting for insurance companies have fallen into the habit of asking courts to pay a victim's compensation not directly to the victim but to the public trustee or ARB. We need to address several questions on two fronts. First, are such orders practical? And second, are these orders even legal? Imagine this scenario. Suppose a 20-year-old victim of a road accident is badly injured. She requires professional nursing care for the rest of her life. The statistical average of a woman's duration of life is 78 years. So, the victim has 58 years of life left. Suppose the defendant is wholly at fault. The future private nursing care costs, say, Rm 10,000 per month. That results in an award for 6.96 million for future nursing care. That money is not, argue insurance lawyers, due and payable to the victim this minute. These days, insurers demand that such compensation be paid to the Malaysian public trustee because they claim so huge a sum is susceptible to be dissipated or abused by the plaintiff's solicitors. This argument is completely inaccurate and incorrect, and for several reasons. Before going into the legalities, let's look at some practical points. The first question is the public trustee efficient at managing its investments? The evidence, unfortunately, does not lead us to that conclusion. The ARB, as you might have realized, is a creature of statute. It manages its investments through a vehicle called Kumpulan Wang Bersama, or KWB. On the 10th of December 2020, the Auditor General laid a report before Parliament. That report covered ARB's investments for 11 years from 2008 up to 2019. The report concluded that ARB was inefficient as a fund manager. Eventually, the government had to step in and cover for the losses and the inefficiency in the performance. So why should one take one's lifeline and hand it over to an inefficient investor? Second, does the ARB charge fees? Of course. Not only does the ARB charge fees, it is statutorily empowered to increase it from time to time, and it does so. The victim cannot fight these ARB increases. She's locked into by any court order that the court makes. So the third question, who will pay the fees? Of course, it's the victim, not the insurer, which brings us to a crucial issue. Do ARB fees reduce a victim's compensation? The answer is yes. Let's calculate the amount of fees payable by the victim. Assume the ARB charges, say, 0.4% per annum on the deposited sum, as we said earlier, of Rm 6.96 million. Rm 334,000 per annum over 58 years would amount to 1.937 million in fees. Over time, the annual fee reduces the compensation. Which court would intend this consequence? Now, that's assuming that the capital sum for 6.9 million is guaranteed by ARB. It isn't. Again, over 58 years, inflation itself eats into the compensation. The High Court, in a case called Jagatish Nagulan and others versus Suresh Balakrishnan and another, in fact stated that the ARB charges a far higher rate of 1 to 2% per annum. That would result in the victim losing vastly larger sums of money, and therefore to make an ARB order would not only be unfair to the victim but goes against high authority. The House of Lords case of Wells and Wells ruled that the courts were not entitled to reduce awards. Lord Lloyd said, there is no room for a judicial scaling down and there's no more reason to reduce the awards. So the fifth question, can the ARB give the accident victim better rates than commercial fund managers? Clearly, no. There is nothing to show that the ARB can grant a better rate to the victim compared to commercial fund managers. Take, for example, Bank Rakyat Berhad. It grants an interest rate currently in the year 2022 of 4% per annum. If the victim deposits her monies with Bank Rakyat, she gains 16.15 million over 58 years. I do not think ARB can match that rate, which brings us to the development of common law in this area. In compensating a victim that he has injured, a defendant is bound by 4 common law rules. First, if the victim has lost an arm, a defendant cannot give his own arm in reparation, so money is paid to compensate the victim instead. The law requires that the victim be put in nearly the same position as she was before the accident. Next, a once and for all lump sum payment must be made. The award must be once and for all. It must cater for past, present, and future damages. Now, the aim of this rule is to prevent plaintiffs from filing new cases in the future for the very same injury if they discover some new treatment is required. If additional expenses are incurred 10 years after the accident, the victim cannot ask for extra damages. Otherwise, cases will go on forever and ever. So the next question is, can courts order payments in installments? The answer is no. An award in a negligence case cannot be subdivided and paid in stages or paid progressively. Again, in Wales and Wales, Lord Steyn ruled that no such power exists with the judges. He said only Parliament can solve the problem. So asking monies to be paid to the public trustee is to create a structured settlement, which Wales said cannot be done. Neither in the UK nor in Malaysia do courts have the power to make any such order. Until there is legislation on these issues, Malaysian courts with respect do not have the power to make these ARB orders. The next question is question 7. Should the victim be asked his consent before such an order is made? In situations such as these, the victim's informed consent is crucial. The money is hers, but previous decisions have not adequately addressed this concept. The next question is, can an insurer dictate how a victim invests her compensation? The answer is obvious. It's no. An insurer cannot dictate how the victim invests her compensation. Why is that? First, under the Road Transport Act 1987 or RTA, no vehicle can operate on a public road without third-party insurance cover. Should a third party be injured in a negligent collision, Sections 91 sub 3 and 96 sub 3 of the RTA require an insurer to compensate the victim, and this is mandatory. Nothing in the RTA allows any defendant to demand that compensation should be paid through the ARB. No such power is given to the court either under the RTA. The exclusionary words, particularly in section 91 subsection 3, to the effect that notwithstanding any written law, and this of course excludes the written law of the Public Trustee Corporation Act 1995, if judgment is given in favor of a victim, then the insurer shall pay the victim. Therefore, the ARB Act cannot make any inroads into these RTA obligations. The courts have consistently accepted that the parliamentary injunction in RTA is a piece of social legislation designed to protect road users. So the insurer's obligation to pay is mandatory, which brings us to the Public Trustee Corporation Act of 1995. So the 10th question is, can the insurers resort to the ARB Act and ask for compensation to be paid to the ARB? A close study of the Public Trustee Corporation Act 1996, we shall call it the ARB Act, reveals several points. First, the ARB Act gives no express power to courts to order investment of the road accident victims' compensation to the ARB. Second, all such powers of the court regarding road accidents victims fall wholly under the RTA. Third, the ARB Act caters only for the management of the estate of deceased person, and even then, where the court may exercise its powers of the appointment of trustees, and these powers, insofar as they involve the public trustee, are subject to the provisions of the Trustee Act 1949, revised in 1978. The one point that has been missed in ARB applications is for a person to be represented, an order has to be made under the Mental Health Act. It's only that act that empowers trustees to deal with the property of the estate of a person under disability as defined in the Mental Health Act. This is a consideration that has not been thought of or discussed in any great length. I think it's an important point. Now, question 11. If the ARB application had not been raised at trial, can appeal courts make an ARB order? The answer is obvious. No. True it is that the Court of Appeal can make any order that the High Court could have made, but an appellate court is also a creature of statute. It can only make those orders that Parliament allows it to make under the Courts of Judicature Act 1965. So the Court of Appeal can grant relief only on matters which are already the subject of an appeal before it. This is explained in sections 67(1) and 69(4) of the CJA. Worse, the Sessions Court has no power under the ARB Act to make any order under the ARB Act. Only the High Court may do so. So, where an insurance company demands for an ARB order at an appeal for the first time, an appeal court has no power, no jurisdiction to deal with that question. So in conclusion, in my humble opinion, the courts have no power to make an ARB order. Even if they did, such an order would interfere with the victim's choice of investing her monies with the fund manager of her choice. Now, if there are fears that the compensation monies would be abused, there are enough legal mechanisms in the law to stop and punish these breaches of fiduciary duties. So there it is. See you again. Goodbye.